Good morning, everyone. Thanks so much for joining us today for our regulatory education session. I'm Lindsay Arndt. I'm the Registrar and CEO of the college, and I am really glad that you came to visit with us on this Saturday morning, even though it is kind of nice outside, I'm not gonna lie. So this session is actually going to be the start of a series. And the series is going to be on the essentials of professional practice and how complaints of professional conduct are handled. So while we've tailored this session to our registrants, which are the MRTs and MRTs and EMPs, it'll also be useful for students, for other regulated health professionals, for sonographers, and anyone else who really wants to understand the process better. So before we get started, I want to acknowledge that many of us are joining from across Alberta on Treaty 4, 6, 7, 8, and 10 territories, as well as the Métis Nation of Alberta regions 1 through 6. The college office is on Treaty 6 territory in Edmonton, the traditional and ancestral lands of the Cree, Saulteaux, Blackfoot, Métis, Dene, Nakota Sioux peoples. We are committed to reconciliation and honoring the treaties through peace, friendship, respect, and understanding. So, about today's event. Today's presentation and all of our presentations from a regulatory perspective are all grounded in the college's core documents. Those are things like the Health Professions Act, our professional regulation, standards of practice, and codes of ethics. If you're a registrant, you can count 1.5 hours towards your CCP. Just make sure to complete your reflective practice review, including your self-assessment, learning plan, and reflection. So a few housekeeping points. So everyone's muted today. So if you want to ask a question, please use the Q&A function on your screen. It's private. No one will see the questions but the staff. We will do our best to get through all of the questions at the end of the presentation. Please keep in mind, if we don't get to your question today, we will do our absolute best to get back to you. And on that note, we have removed the anonymous option for asking questions for that exact reason, because if we don't get through all the questions and you're anonymous, we obviously can't respond back to you. So when you do ask a question today, we will see who's asking the question, but it's only because we want to be able to answer them if we don't get it done live today. If by some chance there's technical difficulties, please stay logged in. We'll do our best to get it fixed. And if you happen to get kicked out, please go back and re-log back in with your registration link that you got when you registered for the session. Okay. So, our life-size picture of Jason. Our speaker today, who is back by popular demand, is Jason Cully. Jason is a partner at Field Law, where he advises numerous regulatory organizations on governance, conduct discipline, privacy, registration. He's also the co-author of the Law of Regulatory Investigations in Canada and the Annotated Health Professions Act, and he's also a sessional instructor at the University of Alberta Faculty of Law. Jason will walk us through how the college handles complaints, including how the process works, the rights and responsibilities of everyone involved. So I'm going to not give you that next slide, and I'm going to say, take it away, Jason.
Thank you very much, Lindsay. You're too kind for me. I'm here back by choice because I love coming to present on these Saturday mornings, and it's a good way to spend some time together to address these kinds of issues and questions that people have, and a way for us to recognize how the Health Professions Act works and how these processes are involved with each of you as registrants. So I'm just going to take some time to share my screen here, make sure I have the right one put up. All right, let's start this from the beginning. All right, so as Lindsay indicated, we're going to talk up today about complaints of unprofessional conduct, and we're really going to be focusing on the complaint aspect. So some of you may have heard of discipline hearings. We're not going to get into the hearings aspect today because we want to know everything that leads up to what happens at a hearing. You want to know, we're going to talk about all of the processes, the rights, and the outcomes that can happen before a hearing occurs, and what happens when a complaint is made and how complaints are made and all of those issues related to that process, because complaints can sound like a very scary thing and they certainly have serious consequences, but it's very useful to have an adequate understanding of why complaints are being made, how they are made, and what happens when a complaint is made. What actually occurs in the background? What is the college doing? What is being considered as this process is going through? So, with that in mind, we're going to talk about 8 different topics here this morning. We're going to talk starting with the role of the Health Professions Act, because Lindsay mentioned this, that when we ground these presentations in core documents like the Health Professions Act, the regulation, the standards of practice, and the code of ethics, we really want to know what those are. We talk about legislation, but we want to have a little bit more of an understanding of what that actually is and how it impacts you as registrants. We're also going to talk about the rights of registrants, you who are involved in the process, and what your role is, because this is not just a matter for the college to carry out. There are certain obligations that you will have as a registrant and certain rights that you will have throughout the process. We're going to talk about mandatory reporting obligations, both from an employer perspective and from a registrant perspective, because there are mandatory reporting obligations that you as a registrant have, and we want to understand those in the complaint process. We're going to talk about the investigation and what that looks like, and again, what your role as a registrant is in that process. As we're talking about some of the different things that will happen in the complaint process, we're going to talk about how a complaints director makes decisions on addressing a complaint. Because as you will see here, and as you see in number 6, the alternatives for addressing the complaint, there are a variety of different options that can arise when a complaint is made. It's not every complaint that is made results in a hearing against a registrant. So we want to talk about here today about what those alternatives to a hearing are and how a complaints director makes decisions on addressing what alternative will be used or if a hearing is necessary. One of those alternatives for addressing a complaint is a dismissal of a complaint. And then we're going to talk about how a complainant may request a review of a dismissed complaint and what that process looks like and why that exists. And finally, we're going to talk about interim suspensions and conditions. So what kind of impacts can have on what kind of issues on a registrant can be imposed, what kind of limitations can be imposed while a complaint is being addressed through an investigation and through a hearing, because that is certainly an important aspect, as it will have some limits on what can be done for a registrant throughout the process. So with those 8 things in mind, we're going to take the next hour to walk through those issues, and we're going to start with the complaint process and the role of the Health Professions Act, because as Lindsay indicated, we always want to ground ourselves in the fundamental basis. As a lawyer, we always talk about jurisdiction, which means, well, what right do you have to do the things you do? What is the fundamental basis that outlines the role process, and how do we get there? So when we talk about the Health Professions Act and the college, the Health Professions Act is really what we would call this umbrella legislation. The legislature, the elected representatives that we have elected to government, they have decided that we need to have this piece of legislation called the Health Professions Act, which regulates all of the regulatory colleges, the health colleges in Alberta, and requires certain processes, certain roles for different individuals, sets out obligations. All of those are decisions made by the government. So you might ask yourself, well, why does the college exist? Why is there a complaints process? Why are any of these things even in existence? They're in existence because the legislature has made a choice as the elected representatives of the public that this is the type of statute, the type of legislation, the type of structure that we need to protect the public. And as part of that, you may have heard of it before, that as a profession, it is a self-governing, self-regulating profession. So each member, each medical profession, they are governed by their own peers. So we have talked about here, the medical diagnostic and therapeutic technologists, they regulate themselves. Other health professionals, they regulate themselves, but they're all under this Health Professions Act umbrella. And you can see on the screen here, we have that Schedule 12, the profession of medical diagnostic and therapeutic technologist, and then that regulation, medical diagnostic and therapeutic technologist regulation, profession regulation that Lindsay mentioned as well. So those are all aspects that fall under the Health Professions Act. And then we have standards of practice, code of ethics, bylaws, policies, and procedures. But really, the key thing here to think is that the legislature has set out a lot or all of the requirements that we're going to be talking about today as part of this complaint process. So it's not just something that the college decided to do on its own. It is something that the government, through the legislation, has said this needs to be in place. All of these things need to occur. And the government has decided that they need to occur as part of that fundamental aspect of protecting the public. That is always the key consideration when we talk about the college and other regulators, is they must carry out their duties to protect the public. So when we look at the Health Professions Act, I'm not going to put up the legislation on the screen because it's quite long, it's quite legal, but what we can think of is that Part 4 of this piece of legislation sets out this process for handling complaints of unprofessional conduct against regulated health professionals in Alberta, including the members of the college and including all the medical diagnostic and therapeutic technologists. So it applies to everyone. This process sets out that complaints can be made. It sets out what needs to be in a complaint. So we're going to talk about that later. And it sets out how those are processed and what kinds of options can be taken when a complaint is made. So again, the fact that complaints of unprofessional conduct can be made is not something that the college decided to do on its own. It is a process that the government has said has to exist for all regulated health professionals, and it is a process designed to protect the public. And we see that at the bottom. Protect public safety, patient safety, ensure accountability of regulated members, and to maintain the integrity of the healthcare system. Because if complaints can't be made, we can imagine that individuals would continue to carry out unprofessional conduct, whatever that might be, and then there would be no way to address it. So these complaints and this process is really a way to ensure that there is public safety, patient safety, and integrity of the healthcare system. When we talk about complaints of unprofessional conduct, I can understand that the term unprofessional conduct may be something you've heard, but may be unfamiliar. It is also defined in the Health Professions Act. So again, when we talk about this type of behavior, unprofessional conduct, the legislature has given it a very specific meaning. It has a broad meaning, but it is something that the legislature itself has decided on. And that definition in the Health Professions Act includes things like displaying a lack of knowledge of or lack of skill or judgment in the provision of professional services. So not providing professional services with proper skill, judgment, and knowledge. Contravention of the code of ethics or standard of practice, which, as you would have seen on the previous slide, are things that the Health Professions Act gives the authority for the college to establish. So we've seen those, the code of ethics, standard of practice. We'll talk about a few of those today. Failure to comply with requirements of the continuing competence program. Conduct that harms the integrity of the regulated profession can also be unprofessional conduct. So is the conduct, even if it's not specifically a contravention of the code of ethics or standard of practice or a failure to show skill or judgment, is the conduct something that harms the integrity of the regulated profession? Would a member of the public look at that conduct and think that there is some sort of negative connotation that applies to other members? Does it bring the profession into disrepute? So those are just some of the definitions of unprofessional conduct in the HPA. There are several others, which include failing to cooperate with an investigator, failing to, or practicing without being registered in the period of time. A lot of different issues, or practicing while being suspended. A lot of different conduct can fall within that definition and be the subject of a complaint of unprofessional conduct under the Health Professions Act. So not just limited to the provision of professional services, certainly one of them, but then we also have, as I've said, code of ethics, standards of practice, actions during an investigation, and that conduct that harms the integrity. So many different things can be subject of an unprofessional conduct complaint. As I mentioned in the last, just briefly, the Health Professions Act grants the college the authority to establish those standards of practice and code of ethics. So that's where that reach of those can come from. The college has established those documents. The Health Professions Act also creates the position of a complaints director for the college. Every regulated profession under the Health Professions Act has this position, and it is really the individual that is responsible for the majority of the steps in the complaint process. So when the college's complaints director, when we refer to that position, again, not something that the college just chose to have. It's not unique to your college. It's not something that was just decided on a whim. The Health Professions Act says that as a self-regulating profession, each college needs to have a complaints director, and that complaints director is the one that gets to make a variety of different decisions, gets to decide on a variety of different processes throughout the complaints process. And we're going to talk about what the complaints director can do and how they exercise their decision-making power. And that's something we'll go through later today. But really, when we think about it, the HPA, this piece of legislation, this decision by the government, this legislation sets out the requirements of the complaint process and what actions a college can take. It really serves to outline procedures for filing and managing complaints against regulated health professionals such as yourselves. And we're going to talk about those procedures, those options, and that process here today, so you have a better understanding of what a complaint means and what happens after a complaint is made. So to start, we're going to go through the complaint process. And under the complaint process, there are a variety of different options and major processes. They are the complaint itself, an investigation, a dismissal or informal resolution, and we'll talk about what that means here today. Those are different. There's a variety of different informal resolution processes that we're going to talk about. There's a review of a dismissal if a dismissal is made, and then there is a hearing and an appeal. We'll very briefly touch on hearings and appeals today with just one slide for each. But as I said at the beginning, we're not going to get into a detailed discussion of a hearing. As Lindsay mentioned, this is going to be a series of discussions and presentations. So a future presentation will focus more on the hearing process itself. Because if we were going to talk about that here today, we'd be here for 3 hours. And I know we don't want to spend all of our Saturday morning listening to me talk. So today we're going to focus on the complaint process. What happens up to a hearing? What happens if a hearing isn't necessary? That's what today's focus is going to be. So I've said complaint a lot. What is a complaint? Well, a complaint under the Health Professions Act is a complaint of unprofessional conduct. Talked about the different definitions of what might be included in that. Again, it can be a breach of the standard of practice, violation of the code of ethics, that conduct that brings the profession into disrepute, failing to practice with knowledge, skill, or judgment. The complaint has to be in writing and it has to be signed. And those are requirements of the Health Professions Act. So somebody can't just call the college and make a complaint. It has to be in writing and it has to be signed by the individual making the complaint. Something important for you to know is that a complaint can be submitted by anyone with a concern. It doesn't have to be just a patient. It can be a patient's relative. It can be a concerned citizen. It can be, we'll talk about this later here today, it can be your employer. So something to be aware of is that it's not just a patient, not just somebody who you provided direct care to that can make a complaint. Anyone with the knowledge of what occurred can submit that complaint. Something else to keep in mind is that a complaint can also be initiated by the complaints director of the college. So the legislature has said, if the complaints director becomes aware, if they have reasonable grounds to believe that a registrant has engaged in unprofessional conduct, the complaints director can bring their own complaint. And that can arise from a variety of different means. Maybe there is a news story. Maybe the college becomes aware of unprofessional conduct or grounds for that through some other source, but that other source doesn't want to make the complaint. The complaints director can then go and bring that complaint themselves. And that's part of that public protection aspect, is that if there is reasonable grounds of unprofessional conduct, but somebody hasn't come forward to bring the complaint themselves, the complaints director can then bring it forward. And that's a part of that public protection, as I just said. In terms of a time limit, some of you may have heard that something called a limitation period or a statute of limitations, where you only have a certain period of time to bring a complaint based on the conduct. Under the Health Professions Act, there is no time limit for making a complaint, provided that somebody is an active registrant. So somebody can make a complaint about something that a registrant did, even if it occurred 3 years ago or longer, or any period. There's not a magic time limit. There may be concerns about the amount of evidence that is available or the reliability of the complaint, but that is a separate question. It's not that there's any time limit before a complaint stops to being able to be made. It doesn't just disappear because of a time limit. That time limit, there is no time limit for making a complaint against an active registrant. If you cease to be a registrant, or a person ceases to be a registrant, a complaint can only be made within 2 years of the individual ceasing to be a registrant. So there is a time limit once you exit practice, once you stop being a registrant, but as long as you are an active registrant, a complaint can be made without any time limit. When a complaint comes in, when that written complaint comes in, the complaints director has a variety of options. So it's not the case that if a complaint of unprofessional conduct is made, automatically a hearing is held. That is not what occurs. So the college can engage in a number of different actions, which we're going to talk about in more detail here today, but I'll just outline them at the beginning. They can encourage communication between the complainant and the regulated registrant. They can attempt informal resolution. They can engage in a more formal alternative complaint resolution process, which has specific requirements under the HPA. They can go get an expert opinion. So if the complaint comes in about a lack of knowledge, skill, or judgment, or something very technical, the college and the complaints director can go get an expert, somebody who is also a registrant or somebody who has the expertise, to provide their opinion as to whether there has been a breach of any of those requirements. They can also conduct an investigation, which we'll talk about here today, but would involve things like interviews, collecting documents. They can also dismiss the complaint. So even when a complaint comes in, if it is clear that the complaint is trivial, vexatious, or lacks sufficient evidence, a complaint can be dismissed right at the beginning. And there can be an capacity assessment. So if there are grounds to believe that the underlying cause of the action complained about in the complaint is connected to any sort of disability or medical condition which incapacitates an individual, the college can go and have a more formal incapacity assessment done to see if that was the underlying cause of the complaint. So you can see a variety of different options. Not everything goes to a hearing right away, but here are a number of possible actions that can be taken at the beginning, and we're going to walk through those today. And one of the things to consider is that they're not mutually exclusive. A lot of them, and almost all of them, can be utilized concurrently. That means together. So if the college is conducting an investigation, it could also be encouraging communication at the same time. It could also be getting an expert opinion at the same time. So these are not one or the other. These are a variety of different tools that the complaints director has, and they can be used together as the complaints director sees fit. And we're going to talk about how the complaints director makes that decision to decide what they're going to use, but we'll talk about that in a bit here. So to start with, going a little bit out of order, we'll just highlight this, that the complaints director can conduct an investigation themselves, or they can assign it to another investigator. So if there is a more experienced investigator, if there's somebody that they want to utilize, it doesn't have to be the complaints director themselves that is conducting the investigation, but they can certainly do it if they so choose. And that is one of the options. There are broad investigatory powers that are given to whoever is conducting the investigation under the Health Professions Act. And again, the legislature has made the decision to give these broad powers, and we'll talk about a bit more of those here today. And there's also a duty to cooperate on the registrant being investigated. So a registrant cannot just refuse to cooperate in the investigation. It's not that same right to remain silent that you have in a criminal proceeding, and it's very different in a regulatory proceeding because of the issues that arise, and given the legislative choice to require cooperation. And we're going to talk about the investigation in more detail later today. But to start with, just want to highlight that once an investigation is done, what options exist? So the investigation has been conducted, interviews have been done, documents have been collected. At the end of the day, the complaints director can still attempt resolution through various means. The investigation has been conducted. They've seen all the evidence. The complaint director says, okay, we still want to see if resolution is possible. So resolution is still an option after an investigation is conducted. After the investigation is conducted, the complaints director can also dismiss the complaint. We talked about that at the beginning, right? That a complaint can be dismissed at the outset if there is insufficient or no evidence, or if it's trivial or vexatious. And a complaint can be dismissed also after the investigation because documents have been collected, interviews have been taken, which show that there is insufficient evidence of unprofessional conduct. And after an investigation, a complaint can also be referred to a hearing before a hearing tribunal. So those are the options. As I've talked about, complaint can be dismissed by the complaints director before or after the investigation. And that, again, is an assessment by the complaints director that there is insufficient evidence to proceed to an unprofessional conduct hearing, or that there's a desire to not pursue those informal resolution processes or to go through those other avenues. If the complaints director dismisses a complaint, they have to give notice to the complainant of the dismissal and the right to apply for a review of the decision. So if you are a registrant and a complaint against you is dismissed, that is not the end of the process. There is still an ability for the complainant to seek a review of that dismissal, and the complainant can request that review by the complaint review committee. So it's effectively an appeal process for the complaint. When the complaints director is dismissing a complaint, they do have to provide the rationale for why the complaint is being dismissed and why it's not going to a hearing or why one of the other options is not being pursued. So that is the complaints director's role and duty. They have to provide notice to both the registrant and the complainant of the reasons for the dismissal. And then the complainant can request a review of those reasons. And that goes to another body. And that's the complaint review committee. And we'll talk about that. And as a complainant has to provide rationale as to why they're seeking a review. What are they arguing that the complaints director failed to do, or that they erred in doing so as part of the dismissal? Again, talked about it very briefly. A hearing is an option. It's held by a hearing tribunal, which is 50% made up of 50% public members who have been designated by the government as decision makers. And then the other 50% of the tribunal is made up of other registrants. So it's a decision from your peers and from members of the public. The tribunal determines if unprofessional conduct is proven based on the allegations before it, and if it is proven, what sanctions should be imposed. Again, we're not going to get into the hearing today in much detail because that will be another presentation, which I'm sure will be of great interest to many. If the hearing tribunal comes to the decision, whatever outcome it says, if there is unprofessional conduct, or if there is no unprofessional conduct, or the sanctions it orders, either a registrant or a complaints director can appeal the decision of the hearing tribunal to council. So there's an internal appeal to other members of council. The registrant or the complaints director can then also appeal a decision of council to the Alberta Court of Appeal. And that is certainly a more formal process, which involves judges acting as the decision maker at that second level, that external appeal. In the internal appeal, it's members of council making the decision. When a registrant is appealing either of these decisions, it's not simply just saying, I appeal. They have to provide grounds of appeal. They have to provide their explanation as to why there was an error in the previous decision. So there is requirements for outlining what grounds of appeal exist. One thing to note is that a complainant, the individual who brought the complaint, they cannot appeal a decision. So if a hearing tribunal makes a finding that there is no unprofessional conduct, the complainant doesn't get to be involved in any appeal. It would be up to the complaints director because they have been given that public protection authority. So with that overview in mind, we've talked a little bit about the process. We're now going to talk about the rights of registrants and their role during the process, because I'm sure that that's a question that you are having is, well, these are all the options, but what do I have to do? What are my protections? What happens to me during this process? During the complaint process, the registrant does have a right to procedural fairness and natural justice. So you may have heard those terms before, that they talk about these protections that you have as a registrant. One thing to think of them is they are just rights that you have that give you a fair process. So it is certainly not a guaranteed outcome or a guaranteed result, but they are there designed, these procedural fairness rights are there to ensure that you have a fair process, that the process doesn't have any concerns in itself, and that when a decision is made, it is a fair decision. So that rights to procedural fairness include the right to be judged by an unbiased decision maker, somebody who is neutral, somebody who doesn't have previous information about the incident, somebody who is unbiased. They are coming to a decision based on the facts before them. You also have the right to know the case to be met. That is a legal way of saying you have a right to know, well, what is the complaint about? What are the allegations? What documents does the college have that are going to be used in a hearing to show that I engaged in this? You have a right to receive those documents at a hearing to know what the complaint is really about. Because you can imagine, if you're saying that a complaint of unprofessional conduct has been made, given that definition I talked about, that can include many different aspects. You don't have to defend every part of your career. You don't have to try to defend yourself in the dark. You have a right to know what the allegations against you are. You also have the right to be heard. That's the right to call evidence, to make submissions. So it's not just the college that is making these arguments at a hearing. You have the right to respond and call your own evidence and make submissions. And that's important because that shows that it's an equal process, that you and the complaints director are on the same level when that hearing is heard. You heard me talk a little bit earlier about an investigation. So you might be thinking, well, what happens during an investigation? What rights do I have during an investigation? The duty of fairness is lower during the investigation. You have a more limited right of procedural fairness during the investigation process itself. And why is that? Because the investigator is not making final decisions. They are not making a decision on if you engaged in unprofessional conduct or not. They're not imposing any sanction. They are out there collecting information. No decisions have been made yet, and there's no prejudice to either party. So during an investigation, at the early stage of the complaint process, you have the right to know what the allegations are, what you're responding to, and you have the right to an unbiased investigator and decision maker, but there's no right to control the investigation. There's no right to demand disclosure during the investigation of all the information the college has. There's no right to tell the college they can't talk to people. There's no right to control the process. You have the right to know what you're responding to. You have the right to an unbiased decision maker, but then the college has the discretion to choose what process to use, how the investigation is going to be conducted. So certainly at the investigation stage, things are different because you are not being subject to any potential negative consequences at that early stage. If there is a hearing, again, we're not going to talk about the hearing in detail, but if a hearing is held, that duty of fairness is increased because there is now then an opportunity for a finding of unprofessional conduct, for sanctions to be imposed. So there is a higher level of fairness owed at the hearing itself. And that would include, again, notice of the allegations and the particulars, disclosure of all the information that is relevant and might be used against you in the hearing, the right to a hearing itself, because there can't be a finding of unprofessional conduct by a hearing tribunal without that hearing, the right to present evidence and make submissions, and the right to cross-examine the witnesses of the complaints directors or others. So that you can certainly see there's more involved. You have more protections of the process at the hearing because of the potential consequences that can arise. One of the things you might be talking about is, well, do I get a lawyer through all of this? We talk about criminal proceedings. We sometimes talk about when we're watching Law and Order. We know that there is counsel that is appointed for individuals subject to criminal proceedings. For this process, you can be represented by legal counsel. You have the right to be represented by legal counsel, but a lawyer is not provided to you. The college does not provide you with a lawyer, and the college is not there to protect you through the process. Because as we've talked about, the college has the complaints director. Their role is to bring these complaints forward to the hearing tribunal to have the concerns addressed. So they can't also be providing you with a lawyer or protecting you at the same time. So although you have the right to be represented by legal counsel, the cost of the lawyer and the decision to get a lawyer is the registrant's own responsibility. You don't need a lawyer through the process. The discipline process under the HPA is intended to be less formal than a court, than any sort of proceedings before a judge, but there is still certainly formalities to it, and there's certain obviously consequences that can arise under those sanctions proceedings. So a lawyer may be something that a registrant wants during the hearing process, but it's not a requirement, and the college does not provide one. The cost of a lawyer is the registrant's own responsibility. And there may be some insurance that will cover that, but that is a separate issue. As I said, you have the right to be represented by legal counsel throughout the process, and that's limited to lawyers. If you're being assisted by others who are not lawyers, such as a union representative or some other representative, there may be some limits on their role because they do not have the same rights as legal counsel. So those are some things to keep in mind about the complaints process and about the hearing. What about the expectations of registrant throughout the process? So expectations of a registrant are that they have candor, they're honest, they're cooperative with the investigation, in which that means they provide documents when requested, they provide responses in a timely manner, they don't frustrate the investigation process. And as I talked about at the beginning, the definition of unprofessional conduct includes a failure to cooperate with an investigation. So while there may be a separate concern that starts the investigation, if a registrant fails to cooperate, the college and complaints director can bring a second complaint for refusing to cooperate in the investigation. That can be its own issue and its own finding of unprofessional conduct. So there is certainly a requirement to cooperate. There is no right to remain silent. There is no right to refuse to cooperate, as you might hear about in a criminal proceeding. You do have to cooperate, you have to provide responses, and you have to provide documents. You also have to maintain confidentiality with respect to all aspects of the investigation. The process is confidential, and it is not for the registrant to be disclosing what is occurring during the investigation. And fundamentally, you have to remain professional throughout. Even though this is a difficult process and can cause concerns, it can be stressful, there is an obligation to remain professional throughout. One thing that we hear about often that is connected to this professionalism is retaliation. So retaliation is the act of doing harm to someone else in return for a perceived harm. It is an act of reprisal, an act of revenge. And what we often hear about and often see is someone that says, well, I had a complaint against me, so I'm going to make a complaint against the complainant or somebody else for the same issue, and just because they made a complaint about me. Important thing to consider is that retaliation against anyone involved in the investigation or the complaint process is prohibited. People who make a complaint or participate in an investigation, so if you have a coworker who's been interviewed, if your employer made a complaint, or if your coworker made a complaint, they are protected from retaliation. You cannot just file a complaint against somebody else just because they brought a concern about you. That is prohibited. And that retaliatory conduct or improper conduct with a complainant or a witness can again give rise to a separate complaint of unprofessional conduct. So again, it is similar to the failure to cooperate. You may have had a concern that was raised about your conduct to start with. And then if there is that retaliation, that can be its own separate complaint and its own separate issue, which is very serious. You can imagine that interference with an investigation or complaint would be taken very seriously because that may have a chilling effect. It may prevent people from bringing legitimate concerns forward. So any sort of retaliation, any sort of conduct that is directed against a complainant or a witness just because they've been involved in the complaint process, that is prohibited and could give rise to its own complaint of unprofessional conduct. And it goes against the duty to cooperate, goes against the duty to remain professional, and is a significant concern. And it can give rise to concerns about ungovernability. And we'll just briefly touch about that because ungovernability is effectively an indication from a registrant that the regulator cannot control them, cannot conduct their authority over them. And then if that conduct occurs, cancellation may then be the only option at a hearing. And we talk about ungovernability, it's things like showing a lack of willingness to be governed by the regulator, in this case, the college, the lack of cooperation with the regulator in addressing outstanding matters, repetitive conduct and the nature of that misconduct, any prior discipline history. And all of this can be used to show that a member or a registrant is just not somebody cut out to be subject to the college or to be a regulated registrant. If there are concerns about a lack of cooperation in investigation, if there are concerns about retaliation against complainants, those can all show that a registrant is ungoverned, that they are not willing to abide by the college's process, and that cancellation may be the only way to protect the public moving forward. So certainly the cooperation and the retaliation, the absence of retaliation, are important aspects of the complaint process and should not be taken lightly. I do want to take a bit of time to just briefly talk about the difference between a grievance and a complaint. And these two are very different processes. There may be some complaints that arise because of workplace concerns, but they are still very different. So a complaint, as we've talked about here today, is connected to that definition of unprofessional conduct and is something under the Health Professions Act. On the other hand, a grievance is internal to the workplace and is about an alleged violation of an employee's rights under the collective agreement. So it is an internal to the workplace while a complaint is external. Grievances are brought to ensure that an employer is adhering to their obligations under the collective agreement to protect a worker's rights at the workplace. The purpose of a complaint is to ensure compliance with professional obligations, to ensure that they are not engaging in unprofessional conduct, and to protect the public. So you can see that there are very different definitions and very different issues. When responding to a workplace concern about and filing a grievance, a member will have the assistance of the union. The union does not have any role or that same role when a complaint is brought. A union cannot grieve a complaint. It is a very different aspect. They can do things in the workplace, but they can't be involved in this complaint process in that same way. And so if a grievance is brought regarding a workplace issue and a grievance is successful, any complaint connected to that grievance is not impacted. And that is an important thing to keep in mind. They are independent, and the resolution of a grievance does not mean that a complaint will be resolved. We're going to talk about this very shortly about reporting obligations from an employer, but a situation may arise where something has happened in the workplace, where it has been alleged that a worker, an individual has engaged in improper conduct in the workplace, and they have been disciplined. At the same time, a complaint of unprofessional conduct is made to the college. The union can then grieve the workplace issue. They can't grieve the complaint, but they can grieve the fact that discipline was imposed, say a suspension. And even they may be successful in having that suspension removed from a worker's record. They may be successful in having it reduced to a written warning. They may be successful in a variety of ways. But even if that grievance results in a resolution of something that indicates the conduct from the worker wasn't as serious or wasn't as alleged, that doesn't have any impact on the complaint process. The complaints director and the college have their own obligations to review the complaint and make decisions on their own, separate from any grievance impact, separate from any resolution that is reached in the workplace. And again, that is also because we're dealing with different concerns. Complaints of unprofessional conduct, as you'll remember, are about lack of knowledge, skill, or judgment, lack of failing to follow the code of ethics and the standards of practice, bringing the profession to disrepute. Those are very different than the violation of a workplace obligation. So important to keep in mind that any sort of workplace discipline and grievance are not going to have any impact on the complaint process. They are very separate. And that is something to keep in mind when you're going through the process. As you've heard me talk about, talked about the fact that an employer may bring a complaint. And it is important to note that the Health Professions Act has mandatory reporting requirements for an employer. The government, the legislature has said, in order to protect the public, we have to have employers reporting the conduct of their workers if a registrant is terminated or suspended, or they resign because of conduct that the employer believes is unprofessional conduct. So if your employer makes a complaint to the college, it's not something that they are choosing to do in a variety of circumstances, although they can. The HPA, the Health Professions Act, the legislation that governs everyone, says an employer has to make the complaint. They must. If they don't make the complaint, if they don't report the incident, they can be subject to a fine of up to $4,000 for the first instance, and that fine goes up from there. It can be $4,000 for the first, $8,000 for the next, and then $12,000. So there are serious consequences for an employer who refuses to meet the requirements that the legislature has imposed on them. So that's where that reporting requirement comes from. It's right in the legislation. It says if you're terminated, suspended, or if there's a resignation connected to conduct that might be unprofessional, the employer has to make a complaint and they become the complainant. An employer who has reasonable grounds to believe that conduct constitutes sexual abuse or sexual misconduct also has to report that conduct as soon as possible, even if there is no termination or suspension or resignation. So you can see that this reporting from the employer is not something that they are just choosing to do, and it is a requirement under the legislation. Registrants also have their own reporting obligations. So under the standards of practice, there is a duty to report other technologists, if there is reason to believe that another registrant is engaging in sexual abuse or sexual misconduct. Registrant also has to report abuse, incapacity, or unprofessional activity, and a registrant has a duty to report themselves for any sexual abuse or sexual misconduct or any finding of professional negligence, charge of criminal conduct or conviction, or unprofessional conduct in another jurisdiction. So you can see that the employers have mandatory reporting, your coworkers have mandatory reporting, you have mandatory reporting. So there's a variety of different ways that the legislature has said, and that the college has said, we need to have complaints brought forward. We need to have them brought forward in a timely fashion, and we need to be made aware of them. So it's not that somebody is out to get anyone else, it's that they are complying with their obligations under the Act and which have been imposed by the college. With all of that in mind, we're going to turn to the investigation process now. So the investigation process is an important part of any complaint proceeding. So if a complaint is made, a complaints director can choose to investigate. If they're going to do that, they have to advise the registrant and the complainant of the fact that an investigation is going to be conducted, that who the investigator is, and they have to give the registrant reasonable particulars of the complaint to be investigated. If there is the possibility that notifying the registrant about what the particulars are would cause harm, they can refuse, and that would be able to conduct an investigation without knowledge. But generally, this is tied back to that concept of procedural fairness, that registrant has to at least know what conduct is being investigated. They don't have a right to all the documents. They don't have a right to everything, but they have the right to know reasonable particulars of the complaint so that they can respond. There is also an obligation to notify the complainant and the registrant of the status of that investigation every 60 days or within a period of time. So really to keep everyone up to date, because investigations can be a time-consuming process. They can be a lot of work. So there is an obligation to keep everyone up to date. When an investigator, whether that be the complaints director or a designated investigator, is conducting the investigation, they have to make every reasonable effort to interview the complainant, unless that is not possible or they decline. So there's an obligation to talk to the complainant who brought the complaint forward. As we've talked about, registrants also have obligations during the investigation process, which include participating in interviews, answering questions, and providing documents. And again, just want to revisit this because of how important it is. There is no right to silence. There's no ability to refuse to cooperate. A failure to cooperate during the investigation is serious and can give rise to a separate complaint. And as part of that, investigators have broad powers during their investigation. They have the ability to compel any person, so not just a registrant, but any person to provide relevant documents, to answer relevant questions, and to provide any sort of document or thing that is relevant to the investigation in their possession. So this applies to both registrants and the complainant and any other witness who might be involved. The investigator has broad powers to ensure that they are uncovering all relevant information related to the complaint. And if there's any concern, the complaints director can apply to the court, requiring cooperation with an investigator from any other individual. So as a registrant, that type of court order isn't needed. You already have to cooperate. But if there's an employer, if there's a witness, or if there's somebody else who's not cooperating, the complaints director can go get a court order. And the investigator can investigate other matters that arise about conduct of the registrant that could give rise to a finding of unprofessional conduct. So while there may be an initial complaint that sets out the scope, that sets out the particulars, if the investigator is conducting the investigation and they come across other serious conduct or other unprofessional conduct, they can continue to investigate that as well. And that might lead to another complaint of unprofessional conduct or other allegations before a hearing tribunal. So really broad powers to go out there to ask questions, interview individuals, get documents, and have all the information they need so that the complaints director can make an appropriate and informed decision on what to do with a complaint. Once the investigator is done their investigation, they prepare a report and they give it to the complaints director. The complaints director reviews that report, which sets out the documents that have been reviewed, sets out the witness statements, sets out all of the information the investigator has found. The complaints director then determines, is this report complete? Do I need more information? Is the investigation properly conducted? And then the complaints director can direct further investigation. They can request an expert opinion at that stage, or they can take some of those other options to address the complaint, that communication, that informal resolution that we talked about before. And we're going to talk about again in more detail. But you can see that can happen when a complaint comes in. It can happen while an investigation is being conducted, and it can happen after an investigator has collected all their information. So really the complaints director has a lot of broad authority to make these decisions at different points of the complaint process. As we've talked about, prior to the completion of the investigation, the complaints director can explore options to address the complaint, and we'll talk about those shortly. But if the investigation and report are complete, if the complaints director believes they have all the information they need, and those other options aren't something they want to pursue, they then can decide to refer the matter to the hearings director for a hearing or dismiss the complaint. We've talked about that. So a complaints director has to notify the complainant and the registrant of any action taken. And as we've talked about, if a complaint is dismissed at this stage or any stage, they have to provide the complainant notice about their right to apply for a review. And we're going to talk a little bit more about that review of a dismissed complaint in a bit. But we first want to talk about the complaints director, how they decide what to do, how they are making that decision about what to go on. And that's what we call a threshold of decision making. So important thing to note is that the Health Professions Act, again, the legislature who has created this position has also imbued the complaints director with significant discretion. The complaints director is the one that gets to decide, do I dismiss this complaint? Do I pursue resolution? What kind of resolution am I pursuing? Or do I refer this to a hearing? They also get to decide what issues to pursue, what not to pursue. If there is a hearing, the complaints director gets to decide what evidence and witnesses to present, whether they should amend or withdraw allegations, and what sanctions to propose. So it is a significant amount of authority that has been given to the complaints director, but that's because the Health Professions Act has said this individual is responsible in this process. They get to make these decisions based on the evidence, based on all of the facts, and they are the ones that are exercising discretion in what to do. Important to note that while the Health Professions Act gives the complaints director that discretion, it doesn't direct how the complaints director is going to exercise it. And that's because every situation is different. The context is different, the facts are different, the allegations are different. So a complaints director needs to be able to exercise their prosecutorial discretion how they see fit based on the facts. They have to do it in a fair manner. Again, we talked about that procedural fairness. So the exercise of prosecutorial discretion has to be fair, but it's up to the complaints director. They get to assess, is there a reasonable prospect of proving facts? If those facts are proven, would they constitute unprofessional conduct? Is a hearing in the public interest? These are all things that a complaints director has to consider when they're determining what to do, whether they should go through the investigation, if there should be informal resolution, what should be referred to a hearing, all things that have to be considered. So as I said, a complaints director has to review the allegations in the complaint, what was alleged in the complaint, what allegations and information arose from an investigation if one was conducted. They have to look at the factual information, and then they have to assess if there's evidence for the allegations to be referred. Is the registrant admitting anything? What is in dispute? What do the documents prove? What will witnesses say? Those are all things that a complaints director has to look at when assessing if a matter should be referred to here. They also have to assess if the conduct is proven. Would it be unprofessional conduct as defined in the Health Professions Act? And would it be in the public interest to send it to a hearing? So when we're looking at these types of issues, complaints director has to look at, say, well, what is being alleged? Is the conduct serious? Is there a clear breach? Is it going to be a contravention or a breach of the standards of practice on a balance of probabilities? Is the hearing tribunal going to make that finding? Is there anything that's unclear? Is a finding unlikely? All of these different things have to be considered. And when we talk about the public interest, we talk about things like, has there been delay in the hearing? Is there going to be any harm on a complainant about having a hearing? All of these things have to be considered. So when we talk about a complaint being made, and we talk about all of these alternative options for addressing complaints, and we talk about the referral to a hearing, all of the power to decide what to do has been given by the legislature under the Health Professions Act. Again, that statute that we talked about right at the beginning that sets out all of the jurisdiction, all of the authority, it gives that discretion to the complaints director to make those decisions on the circumstances. So if a decision is being made in any particular complaint, the complaints director has looked through all of these different issues, has looked at what sort of discretionary decisions they can make, and has determined which is the option that they want to pursue. So it's not just a decision made on the basis of no evidence. It's not anything that is being made outside of their authority. They have the authority and the jurisdiction to make those decisions, and they've looked through all of these processes to deal with that. So that is how decisions are made under the complaint process. And importantly, we're going to talk about, I've been alluding to them, these alternatives for addressing complaints, but we'll talk about these in a little bit more detail because these are exercises of discretion from the complaints director. After they've looked at all the circumstances, they've looked at the investigation results if one has been conducted, they then decide, what do we do with this complaint? Is there enough to refer it to hearing, or should we deal with these in other ways? And some of these alternatives are communication, resolution with consent, formal alternative complaint resolution, or dismissal. And these might be options if there's insufficient evidence to prove the allegations, or if it's not in the public interest to proceed to hearing. There can be a variety of different things that might impact whether a hearing should be conducted. And these are all options that are available. And as I said, not everything goes to a hearing. So the first option, communication. So the Health Professions Act says that the complaints director can encourage the complainant and the registrant to communicate to see if the two of them can come to an agreement to resolve the issue. Complaints director can say, well, certainly if there's an allegation of sexual misconduct, sexual abuse, something serious, this isn't going to be an option. The complaints director is going to not say that those two individuals have to try to talk it out and resolve something amongst themselves. But if the complaint is something relatively minor, if it's a billing dispute, if it's a lack of communication between the two, this can be something where the complaints director can become involved and say, you two see if you resolve. If the complaint isn't resolved between the two, complaints director has all their other options to proceed. But if the complaint is resolved by the two, that can be the end of the complaint. Is if there was simply a misunderstanding, if further communication will resolve the issue, that can address it without a hearing. But again, something that is only going to be useful for relatively minor situations and not a variety of different complaints. Another option is resolution with consent of the complainant and the registrant. In this process, the college is involved. The complainant and the registrant have both agreed to resolve the complaint, but it's different than that communication. This is an informal resolution that is still quite formalized. There can be a document. Generally, a document will be drafted that is called an agreement and undertaking, where as part of the resolution, the registrant is agreeing to a variety of different facts. They're making admissions on certain things often. And as part of it, the registrant is agreeing to go through significant obligations or have significant terms. So as part of this, an registrant can acknowledge they engaged in conduct. They can even admit it was unprofessional conduct. And then as part of it, the registrant can undertake to complete courses. They can undertake to pay a fine. They can undertake to be suspended for a period of time. So all of these are significant outcomes and are serious, but there is some flexibility, and it allows for the parties, the complaints director and the registrant, to be creative in addressing a complaint that will allow a good resolution. It will address the concerns of the complainant. It will provide for remediation. It will protect the public, but it's all short of a hearing. There's no finding of unprofessional conduct. There's no written decision from a hearing tribunal outlining all of the conduct and why it's unprofessional, but there can certainly be admissions of conduct. There can be acknowledgements from the registrant, and there can be significant obligations as part of it as well. So this is effectively a contract between the registrant. They are promises from the registrant to the college, to the complaints director, about all of the things that they agree to and all of the things they're going to do to resolve the complaint. And they can look very similar to sanctions ordered in a hearing tribunal, but it's all done by agreement without that binding. And again, there can be flexibility. There's a ways to be creative in these issues. But the important aspect of this is that the registrant doesn't go through a hearing. There's no finding of unprofessional conduct. There's no costs related to their defense. And it allows the complainant to have their complaint addressed early. So the public is protected and the registrant doesn't have to go through the hearing process. So that is a significant aspect of what gives good benefits to both sides, that the complainant is having their concerns addressed, the registrant doesn't have to go through a hearing, and the public is being protected. So resolution with consent is a very useful tool that is utilized on a high basis by the college and by the complaints director because of how it can result in good outcomes for both sides. You've heard me mention complaints being dismissed. So again, complaints can be dismissed if there is insufficient or no evidence of unprofessional conduct. So again, that can be before an investigation or after, where the complaints director is saying, this is, even though the complainant has a concern, this isn't actually something that is unprofessional conduct, or there's a lack of evidence, or this is a trivial complaint. So again, you've heard me say this before. If the complaint is dismissed, the complainant has to be given reasons of why the dismissal occurred, and they have to be given 30 days notice of the right to review the dismissal. If a dismissal review is brought, the registrant has to be advised of that application for review. So a registrant will know if the dismissal is being appealed. And again, this goes to show that if a complaints director dismisses a complaint, they've said there's no issue to go to a hearing. That is not the end of the process. The complainant can still appeal that. So that is something for registrants to keep in mind. And if there is a review of a dismissal, a registrant has to provide, or sorry, the complainant has to provide reasons in their application for review. And then the registrant has the opportunity to provide a written response to the application. So the complaint is dismissed. The complaints director provides reasons as to why the complaint is dismissed. The complainant then requests a review. In their application, they provide reasons for why they think there should be a review of that dismissal. And then the registrant has an opportunity to respond, usually in writing. The complaint review committee could allow oral submissions, but that is quite rare. So generally, a registrant provides their response, and then the complaint review committee reviews all the documents. They look at the application for review and the reasons the complainant says that the complaint shouldn't have been dismissed. They look at the registrant's response and why the registrant says the dismissal was the proper outcome. They look at an investigation report if one occurred. They look at the expert opinion if there was one, and they look at the complaints director's written reasons for dismissal. Then that complaint review committee, which is created under the Health Professions Act, again, one of those bodies that the legislature has said has certain requirements, they meet to review the documents and to decide if the complaint what should happen with the dismissed complaint. And as part of that, they decide whether they should confirm the dismissal, whether they should direct further investigation, or if they should refer it to a hearing. The complaint review committee is looking at the reasonableness of the complaint director's decision. They say, was it reasonable to dismiss the complaint? Should they have sent it for further investigation before making a decision? Or is this something that needs to go to a hearing? Was the complaint director's decision to dismiss the complaint unreasonable? And this is really something that needs to go to a hearing. At the end of that, the committee has to provide a written decision outlining their outcome to the complainant and the registrant. So the registrant will know the reasons why a complaint review committee made the decision it did. And this is just something to keep in mind, that this goes to when we talk about procedural fairness for registrants throughout the process. The complainant also has some rights under the Health Professions Act, where the legislature has said, well, if you make a complaint and the complaints director, exercising their discretion, reviewing all the circumstances, decides to dismiss the complaint, not pursuing one of the other alternative complaint processes or resolution processes, not referring it to a hearing, they just decide to dismiss the complaint, you as a complainant have a right of appeal. You have this one chance to request a review, to have this review committee decide if that was a reasonable outcome. So you can see it's a little bit of a check and balance on the complaints director's exercise of discretion. Again, complaints director gets to make the decision, and then the committee reviews it for reasonableness, but there is that check in the process that provides the complainant with some options. And that's why that exists. And again, if you are the subject member of a complaint and there has been a review and a request for review, it's not something that the complaints director can ignore. It's not something that is unusual. It is part of the statutory process, part of the process that the legislature has said needs to happen to provide rights to both the complainant and the registrant as part of it. You can see there's still procedural fairness during this dismissal review process, but it's just that aspect to say, if there has been a dismissal, complainant has some options. Turning to the last issue before we get to questions today, I'm going to talk about interim suspensions and conditions. This is a little bit of a different topic, but something to keep in mind as part of the complaint process. What this means is that under the Health Professions Act, while there is a complaint that has been made, so important to keep in mind that when there is a complaint, there's been no finding of unprofessional conduct yet. There are allegations that an individual has engaged in misconduct, but there hasn't been any determination or outcome that would generally result in a sanction. However, if the complaints director is of the view that there are public protection concerns, if there is risk to the public, during this complaint process, the complaints director can recommend that a registrant's practice permit be suspended or that conditions be placed on their practice permit while the complaint is being investigated, while it's being reviewed, and while the process is undergoing. So complaint can come in, complaints director can look at it and say, oh, that is very serious. This individual, even though they haven't been convicted of anything, there hasn't been any finding, this is such a serious complaint with such important evidence that this person cannot be practicing. Or there has to be some conditions on this person's practice while we carry through our investigation and while we deal with this. So it is a limitation imposed on the practice of a registrant prior to any finding, prior to any acknowledgement, prior to any actual outcome. So it's an interim suspension or condition, and it is very serious. There is a high degree of fairness that is owed when a complaints director is recommending this decision to the decision maker who has been appointed by council. So the complaints director makes the recommendation, but the actual decision whether to impose an interim suspension or condition is made by the decision maker appointed by council. When the complaints director is making a recommendation, there's a variety of different things they look at. And again, this is part of that discretion and all of the circumstances. They look to show, well, what actually is the conduct being complained about? How serious is it? Is it something like sexual misconduct, sexual abuse, or is it something that may be less serious? Is such conduct likely to be repeated? Does the registrant have any past disciplinary history that would suggest that this type of conduct did occur? Is there harm that can't be remedied? Or is there risk of harm that would happen if this condition or suspension isn't imposed? What are all of the circumstances? What interim measures are necessary to protect the public? That is the key question, is that when the complaint is being investigated, being reviewed, is there risk that the public will be harmed if no interim measures are used? So if there is risk, the complaints director can seriously consider and recommend these types of interim suspensions and conditions. Because again, as we talked about at the beginning, the whole purpose of the college complaints director complaint process is to ensure that the public is protected. So these interim measures are all about protecting the public, preventing repeated harm, and ensuring that there is no ongoing misconduct from the registrant. And these are all things that a complaints director has to consider. If after considering these circumstances and determining if an interim suspension or condition is appropriate, the registrant, the process, what happens then is that the registrant has to be provided notice from the complaints director of their intention to seek these interim suspension or conditions. The complaints director tells the registrant, based on these concerns, I'm going to make a recommendation. And then the registrant is given an opportunity to respond and make submissions. So we talk about that again, the right, we talked about the procedural fairness and the rights of the registrant, the right to know what the allegations are, the right to respond and have an unbiased decision maker. Those are all part of this process as well. You have the right to know what conditions or suspensions are being recommended and why. You have the opportunity to respond. And then the decision maker who is unbiased, who's been appointed by council, provides written reasons for their decision, saying, is there grounds for an interim suspension or condition? If so, here's what they are and what conditions or suspensions are appropriate. There can be circumstances where it's urgent and the registrant may not have an opportunity to respond prior to the decision maker making their decision, but there would be an opportunity for the registrant to respond after and seek a review. And as part of this, that right to review, if a decision maker imposes an interim suspension or conditions, the registrant can make an application to the court to stay the decision. And that means that the suspension or condition don't come into effect because of some other concern. So there is that opportunity to make submissions in response, have the unbiased decision maker, and then the right to appeal should these conditions or suspension be imposed. When we look at the type of interim conditions that could be imposed, so there could be a suspension. We'll talk about the suspension first. So a suspension could be something that says the registrant's practice permit will be suspended until a hearing tribunal occurs or until the complaint is resolved in some fashion. So that can be a very significant suspension imposed. It can be an interim suspension until the matter is addressed. There can also be these conditions that can be imposed. It can be things like practicing under supervision, having a chaperone present whenever there is a patient involved, limiting practice to a particular area, potential monitoring for drug and alcohol or other mental health concerns. So there's a real variety of conditions that can be imposed. And again, all of this at the end of the day is about protecting the public. These conditions and suspensions are being imposed because a complaint has been brought forward. There's been allegations of unprofessional conduct, and there is some information to support that. And the complaints director has decided, as well as the decision maker, they have decided that the public would be at risk if a registrant was able to continue to practice without any of these limitations. So that's always what the aim is. And I said it at the beginning, and I'm going to end with that and saying that the complaint process, including the interim suspensions and conditions, the investigation, the alternative resolution processes, all of this is aimed at the protection of the public, which has been the legislature's goal under the Health Professions Act in creating the college, in establishing the duties and rights of the complaints director, and establishing these mandatory reporting requirements and all of these other issues. It's all about allowing these complaints to be brought forward to ensure that public protection persists throughout the process. And with that in mind, I've reached the end. I know we're getting close to 10:30, so we want to leave some time for some questions. So thank you very much. And as I said, beyond these discussions of the complaint process, next step would be the hearing. You've heard me talk about the alternatives to referral to hearing, what happens before a hearing. The next process would be a hearing, and that's what will be discussed next time, where then that will be where issues of cancellation of practice permit, costs, all of those kinds of things can arise at that stage. So we'll talk about that in the next regulatory education session. So with that in mind, turn to any questions that might be present from anyone here, and I'll turn it over to Michelle or whoever is going to be addressing the questions. So thank you very much.
Thank you very much, Jason. A lot of the questions have already been covered during the presentation, but we have a few here. First one, how is an unbiased decision maker ensured?
So that's a really good question. So it is part of that procedural fairness aspect, and all of the decision makers that are appointed by the government go through a screening process to ensure that they are going to have that unbiased position. And if there's any concerns about a conflict of interest or bias due to previous engagement, prior knowledge of each other. So, for example, if a registrant and one of the hearing tribunal members or one of the decision makers for the interim suspension, they know each other personally through work, there is a process where every decision maker has to declare at the beginning that they're unbiased. And then if a registrant has a concern, they can raise that. And then there can be a decision as to whether the person should be replaced, if somebody else should be the one making that decision. So there's always an opportunity to have those issues of bias addressed if there are concerns, but there's also things happening in the background to ensure that every decision maker is aware that they need to have a lack of bias, because if they do have bias, that decision is invalid, it can be challenged. And that's not something that anyone wants. So there's always screening for bias that occurs.
The next one, can the college take my license away?
So as we've walked through the process, you've seen me talk about everything that has to happen, the registrant's rights, the interim conditions and suspensions. You would have noticed that I didn't say any sort of interim cancellation or any of those kinds of issues. So through the complaint process, the college can't unilaterally take a registrant's license away because of a complaint. If a hearing tribunal, which we'll talk about next time, makes a finding of unprofessional conduct, cancellation is one of the sanctions that can be imposed, but that is going to be after a full hearing. As part of an informal resolution, we talked about that agreement and undertaking, a registrant can agree to give up their practice permit. They can agree to resign and have their practice permit canceled in that fashion. But again, that's by agreement. So, and then as I said, with the conditions and suspensions, conditions, suspensions, no cancellation. So cancellation is something that can happen from a hearing tribunal or with agreement of the registrant, but the college cannot unilaterally cancel a registrant's practice permit because of a complaint. There has to be that finding or acknowledgement.
There's a question that came through, how many complaints were received each year? So I can address that. We report that in the annual report every year, so you can look that up in the annual report for how many complaints and a breakdown of that. Another question, do I get support through the investigation process?
So I would have talked again, this goes to relate to the discussion of the investigation process, is that the college isn't there to support a registrant through the complaint process. The college's role is to process the complaints in accordance with what's required in the Health Professions Act, which I walk through, and it's there to protect the public. So the college would not be supporting you as a registrant because the legislature has said it has its own duties and obligations to move the complaint forward to address the concerns that have been brought in. As a registrant, you can seek assistance from a lawyer. You can seek assistance from a representative that might be assisting you, but that is going to be at your own cost, at your own expense, at your own discretion. So it is something that you can choose to have. There's no established support system through the college because, again, college's role is to bring those complaints forward and to address the complainant's concerns as required. So any sort of support would be something that you would seek on your own through a lawyer, through private means, or through any sort of registrant or any sort of potential union representation. But again, that is very different than the grievance process and that role. So there's not support from the college, but you can seek support on your own.
Any other questions out there? Most everything else was addressed. Is the name of the complainant's the name of the complainant's name released to the registrant? So is the complainant's name released to the registrant?
Yes.
Is there a whistleblower policy to protect the identity of the complainant if they are also a registrant member of the college?
And so this goes to one of the aspects that we talked about, is that a registrant has the right to know the allegations and particulars against them. And generally, almost always, that also requires the identity of the complainant to be disclosed. And as we've talked about, the complaints have to be made in writing and have to be signed. So as part of that, as part of the investigation process, part of the complaint process, the registrant is going to know who brought the complaint forward, and they're going to have to, because if it goes to a hearing tribunal, the complainant is going to have to testify at that as well. So they have a right to know the allegations, and that is something that is going to be disclosed to the registrant. So that whistleblower policy is not really something that applies in these circumstances because of the significant outcomes that can happen for a registrant. So a registrant will generally know who the complainant is and what the complaints against them are. And then, as we talked about, although that their name will be disclosed and their identity and the particulars are disclosed, the registrant cannot retaliate. They cannot engage in any sort of backlash or retaliation just because of that complaint process. And there's protections for the complainant through that fashion, is that no retaliation, additional complaints of unprofessional conduct can be made. So a complainant's name will be disclosed generally, almost always, and that can be an issue, but there are protections for the complainant in that other aspect about the conduct that's expected of a registrant throughout the conduct process and the complaint process, and the additional complaints of unprofessional conduct that can be made.
Does it ever come down to their word against yours?
So there can certainly be complaints where it's a situation that's arising where it's not something that's based on documents, there was no witnesses available, and it's really just one person's word against another person's. And that is something that can happen, and it arises in certain circumstances more often than others. And if that's the case, that comes down to what we call a credibility contest. So in that situation, the complaints director and then the hearing tribunal, if there is a hearing, they will look at the certain circumstances. They will look at the ability of each individual to recall. They'll look at the consistency of the version of events with other external circumstances, other evidence that might be available, such as place it occurred, the plausibility of the version of events, how it holds up to scrutiny. They'll look at those issues. They'll look at if there's any motivation from either party to provide a certain version of events. They'll look at if there's anything that gives concerns about the credibility or reliability of that version of events. And then there can be an exercise of discretion from the complaints director, whether there is an ability to say this complainant or this registrant lacks credibility at the early stage, I need to refer this to a hearing for a decision, or if there's something that undermines the credibility of a complainant or registrant at the early stage. So that can certainly be taken into account. And then if there is a hearing, the hearing tribunal then has to determine which version of events is more likely than not. It looks at the word of each individual party and then comes to a conclusion on who they believe on all of those things I've discussed. Who is more credible, who is more reliable, and then they make a finding of whether there is unprofessional conduct or not based on that assessment. So yes, long story short, in the lawyer answer, it can come down to a different version of events, and there can be a determination of who is more believable.
Is the complaint director an elected or appointed position?
So the complaints director is a position that's not elected. So there is the council who is elected, but then the complaints director is an employee of the college where that determination is made by council. So it's not an elected position, but there is a determination made by the elected body, which is council.
And the last one I see here is, if you had a complaint one time that was dismissed, can it be held against you if another complaint is filed against the individual?
So if the complaint is dismissed, then that will certainly have an impact. The fact that past complaints have been made is something that can be considered, because even if the complaint is dismissed, the previous allegation is something that can be considered. But if it's been dismissed, that also has to be considered. So again, it can be something that is relevant, but if a past complaint has been dismissed, that also has to be taken into account. And that's part of that discretionary decision-making, that prosecutorial discretion. We look at all the circumstances and say, well, was there something about the previous complaint that gives rise to concerns again? Or is this a complaint that was made which was lacking evidence and has no bearing on the second complaint? So it can certainly be relevant, but it's not going to be determinative in any fashion, particularly given the dismissal.
There's one question here about PLI coverage through CMRT membership, which I'm thinking you probably just have to check with CMRT to see the full costs of a lawyer and what fees are covered or not. So you'd have to probably contact CMRT to see what your coverage includes. Jason, do you have anything to add to that?
I do not. That is the perfect answer, Michelle.
No further questions, and we're at 10:27. So, Lindsay, do you want to close it off?
Yes, as long as my video and audio wants to come back on, absolutely. Okay. So I'm just, Jason's disappeared already. Geez, he's fast. So I'm going to thank Jason for the helpful presentation. I know that was a lot first thing on a Saturday morning, but you did a great job, and you and Michelle both tackled our questions. Hopefully it's given the registrants a clear picture of how complaints of unprofessional conduct are managed up to the hearing and why it matters. So before we wrap up, just gonna, 1 second here. Okay. Maybe. Is it sharing my screen? Oh, there we go. Okay. So before we wrap up, if you are a registrant, now is the perfect time to log into your college portal and select your MyCCP and complete your learning plan objective. Now, simply this, start by choosing a standard. You can pick 2.0 as an example. It's a good option. However, we're going to leave that critical thinking decision up to the registrants as to where you guys think it should go. Figure out the indicators that match up with what you learned. And then for the learning activity, record it's an attended in-service or webinar.